I'm Justin Brady from iowapodcast.com. Last time, being a worker, where does your work and where do your rights collide? Like, that's confusing. Whenever we get lawyer stuff and law stuff and what your actual rights are, it's a bit of a mire. And so what happens if you have a situation, a work comp situation, and medical care is involved? What are your actual rights? Do you have any rights? We're going to talk about that today with Nate Boulton, the workers' rights attorney here in Iowa. Welcome back to the studio.
Great to be back.
So we had you last time and ran the show, and apparently there's a lot of people that want to know the answers to this stuff because people are Googling this stuff and they're finding that interview. So it makes sense to have you back again.
Yeah. Questions lead to more questions, right?
Yeah. I appreciate you working with me on this segment here. So work comp, I know nothing about this stuff, but what happens if someone has a work comp medical issue? Like, let's just 30,000 foot view.
Yeah.
Can you walk us through what that means, how that works? Step one, this is going to happen. Step two, this is going to happen. Just give people a 30,000 foot view on what they're in for.
Yeah. So most people know absolutely nothing about workers' compensation until they're injured and have a workers' compensation claim. And then they want to know all about it, right?
Right.
And so the first thing people ask is, well, what do I do for medical care? Do I just go to my own doctor? Do I have to go through some process? And the answer is Iowa is a state, and this is very state by state specific, but Iowa is one of the minority of states that says the employer gets to designate your medical care provider.
Oh.
So if you slip and fall on your own sidewalk, you just go to your own doctor and you turn it into your health insurance, and they don't get to say, no, you were supposed to go to somebody else. For the most part, they will pay whatever doctor you choose, as long as you choose a reasonable physician. There are some questions about in-network and out-of-network, but overall, you get to go where you want. Work comp is not the same. Work comp, you turn in your work-related injury, and they will authorize a specific facility or physician for you to go see, and then they will authorize care from there. So what happens when you go to a care provider and you don't think that person's got your best interest in mind?
This is obviously a good question.
Yeah, and there were some really bad examples early in my career. There was one doctor out there who literally called his practice company medicine PC. And if you're an injured worker and you get sent to company medicine, I think you're suspicious that they may not be exactly looking out for you.
Sure.
So we don't have that practitioner around anymore, but there's still that kind of underlying question of, am I being sent to a reasonable course of care here?
Sure, that actually makes sense, yeah.
Are they just trying to minimize the cost and just get me back to work as fast as I can, right? So that's where some of these questions arise. And the reality is workers do have a right to a second opinion. They have a couple of different things that come up in a work comp case. The first kind of second opinion is if you're suspicious that the care that is being provided is unreasonable, you can request a hearing in front of a judge to have that question answered.
Really?
So if I say, hey, I'd like to get an MRI. I don't think that this physical therapy is working. The problem is really serious. It's still not getting any better. And you can just keep getting sent to more physical therapy and nobody takes an image. You could say, I want an MRI. The insurance company says no. You can go to a judge and say, is it reasonable to request this? And is it unreasonable to deny it? And a judge will make that determination. And that happens pretty fast. You don't have to wait all the way until the hearing for all the other questions in your case. The judge will look at that one issue and decide, is the care being authorized reasonable? And if it's not, is what is being requested by the injured worker reasonable? And if that happens, the judge will order that care to be undertaken. So that's the first one. The second one is an absolute right. If you've gone through a course of care and you feel like your impairment rating and work restrictions aren't accurate and you want another opinion, you have an absolute right to have a second opinion with a doctor of your own choosing, paid for by the insurance carrier, to have that kind of question answered. Is the rating too low? Are my work restrictions appropriate? Is more care needed? And that's where you really want to be careful who you choose, because you only get that once. And if you use that and you choose a doctor that is a general practitioner and maybe not as credible and persuasive as the orthopedic surgeon that has specifically treated the spine or something like that, that's where you want to have the advice of an attorney, frankly, to make sure your one shot at that kind of a report and opinion is the one that's going to be persuasive.
Okay, so in Iowa, the law is that the companies handle the medical care. In the
Right.
case of a work comp issue, like
Right.
like you said, if it's your own thing, that you can still go to your own doctor. Nothing's different.
Right. You get a
But-
cold, you just go to the doctor.
Right. But if it's a work comp issue and it happened at work, and the workplace is responsible to some degree, they get to pick the medical facility, but that's not it. That's not the whole thing. If you have doubts and you have concerns about the medical care being provided, you absolutely can contest it.
Right.
The challenge is, because even as I heard you describing it, I was like, hold on, what?
Yeah.
And so the challenge is that it has to be done carefully, because you mentioned in one case, you have one shot. Because, again, obviously the legal system doesn't want to be overwhelmed with people constantly bickering about things, right? And so you have one shot to get this right. So make sure that the second opinion is done with legal counsel.
Yeah.
Right.
So you've got two different things that kind of come up.
Yeah.
Employer choice of care means they get to authorize at least the initial care provider. It doesn't mean they just get to absolutely choose and control care. So if they decide you don't need surgery, they can't just say, we're not going to authorize surgery, and you have no alternative. You can go to a judge and ask if it was reasonable to deny you that surgery or an MRI or something like that. Separate from that, you have an absolute right, whether you have, reason to doubt the care or not, you have an absolute right to a one-time evaluation with a doctor of your choosing after you've had a permanent impairment rating. That's your one kind of counterbalance in this employer-controlled choice of care and employee right to a second opinion at least one time during the course of that medical care progress. So those are two different things, and they're really important things, because sometimes people are just resigned to, oh, it's employer choice of care, I just don't get to do anything.
Sure,
That's not right. You're not fully resigned to it. It has to be reasonable care. And then secondly, when you get all done with the care and an impairment rating is provided, you absolutely get to ask another doctor, is this fair? And you get to choose that doctor. You don't have to defer to anyone in the insurance carrier's system. You get to choose your doctor. And that's, again, it's really important to talk to an attorney before you do that, because you want an expert that's just as credible as the one that the employer has used.
Now, is it going to be a common scenario when, I would assume some of this comes through HR, like HR is handling some of this. I would also assume HR, as much as people want to think HR are attorneys, they're not. And so is it common where there's either, I think generally most people want to do good by others. They're put in positions where they're not educated, they don't understand, or they're conflicted. However, is it an issue where someone has a work comp issue and their HR person or their selected person they're supposed to talk to at their company doesn't understand, and so they just say, no, you don't have those choices, or they even listen to this episode and they're like, hey, there's this guy on iowapodcast.com saying that I had these rights. Is it common for them to say, we don't have that here though, or that doesn't apply here because? Is this a common refrain? Like, will people inform someone who's injured about their rights, or will they just shut it down and say, it probably doesn't apply here?
Correct. And usually it's not the kind of evil, sinister HR person is trying to do something bad. It's that they don't understand the work comp law and requirements. Some common things that people are told by HR people that are just wrong. You have to report your injury within 24 hours here. No, you have 90 days to report an injury. And the biggest reason for that is to make sure people don't feel like they have to turn every hangnail, fingernail injury the day it happens. You can wait 90 days and see, oh, this is serious, right? This back strain isn't going away. I need to tell somebody about it at work, versus turning in every bruise just in case it ends up being something more concerning.
Sure.
So sometimes an HR person will say, nope, I can't accept that. It's over 24 hours or 48 hours. Well, that can be your company's policy, but 90 days is the law. And so your company can have a policy. We require you to report injuries within 24 hours. That's fine, but you can't deny someone turning one in within the 90-day period. And so things like that happen. Returning to work with work restrictions. Someone in HR can say, well, we just don't accept any work restrictions. Well, that would actually be a violation of the Americans with Disabilities Act. If you have workplace restrictions that are reasonably accommodated, you get to go back to work, and you get to have that employer work with you to find reasonable accommodations for your new disability. So just things like that generally are misunderstandings, as opposed to, again, some evil HR person just trying to get that worker. Usually it's them just understanding, well, these are the essential functions of the job. We don't deviate from that for anybody. Well, you can't just have a policy not to do that. You do have to work with the person to see, well, wait a minute, is there a reasonable way to accommodate this person to allow them to still perform the essential functions of that job? So there are a lot of those questions that come up. And again, that's why you do need to talk to an attorney.
Right.
And that's why HR needs to talk to its attorney too.
True,
right?
true.
They need to engage legal counsel when they don't know these answers, rather than getting something wrong and potentially creating a really big problem for the employer.
It seems like most of your job is like almost being a counselor versus an attorney. Just
Absolutely.
a counselor with legal understanding. Because as you describe this, we've talked obviously off air and on air. As you describe this, it's almost like two parties don't quite understand each other. Right. And your job is to say, guys, you need to agree on things and put it. The reason we put these things in writing is because we got to get those abstract concepts out of your head and onto paper so you can see it and so you both can agree. Like, that seems like most of what your job is.
Absolutely. And the medical care thing is a great example. Most workers want good medical care that allows them to fully recover from this injury and get back to work and get back to making the same money that supports their family the same way they have for years. That's the goal. And the other side of the coin should want that too. We want that worker back to work, so we don't have to replace that person. We want that person to bring their experience back to the job. It's just the way they go about it. Sometimes they assume things about each other, right? That you're trying not to work, or you're trying to get me not to work. And instead, they probably both do have the same goal. They just don't quite see it the same way. And a lot of times we can just alleviate that by getting that injured worker the care they need, allow them to get back to work with as few restrictions as possible because they got good medical care, and back to earning the same wage, so we don't worry about a loss of earning capacity workers' compensation claim. We've got that worker earning their actual wages.
Yeah, it's almost there's that phrase, clarity is kindness.
Right.
And it's people don't want to be clear because they feel like they're going to offend someone else. But at the end of the day, that clarity is absolutely important. So I think what's really important to take away from that aspect is that company policy doesn't supersede law.
That's right.
Your company can say whatever they want. It could be true. It could be false. But if you think something's up, or you were like, I just that doesn't quite align with what I heard on this show, talk to a legal professional. Now, is that that's not an insane lift, right? Just for an initial consultation. It's not like it's going to set them back like $50,000. I think this is one of the concerns people have with I can't go to legal counsel, dude, because I don't have the money for that. This is not a crazy lift for an initial consult, right?
Correct. For any injured worker that has questions about things like this, almost every claimant side attorney for workers' compensation is going to give you a free consultation.
Really?
They're going to talk with you and see if you have a claim. And then some people are worried, well, an attorney's going to cost a bunch of money. Most attorneys are going to take these on what we call contingent fee agreements. So the only recovery that's made by that attorney is if they are able to get benefits over and above what your insurance carrier and employer were going to pay you anyway. So that's the way that works. So that takes a lot of that stress about, I shouldn't call an attorney, or I shouldn't talk to an attorney, it's going to cost me something. For the most part, the only thing it's going to cost you is things that you don't even have coming right now anyway. That attorney's going to have to help you get more work comp benefits in order to get any kind of fee. And so that's a big thing. And I will tell you, what makes my phone ring is not people looking for more money in workers' compensation cases. Most people will call me because they didn't like what happened in their medical care. They will say, it was weird they wouldn't authorize more physical therapy even though the doctor was telling me I needed it. Or
interesting.
And if I would give one piece of advice to most insurance companies out there, if you don't want people to bring workers' compensation attorneys or claims with attorneys, answer their questions reasonably on medical care.
Right.
And most of them don't come to me. Or Treat them well in terms of that return to work. Don't get too aggressive with them, telling them they need to be back full duty in order to come back, or trying to rush that process. That's when they start to get suspicious and say,
They get nervous.
I think you're not looking out for me, and you're looking out for the company, not me. And that's what steers them to calling an attorney. And quite oftentimes we will find out, well, it's not just the medical care that's been shorted here. It's been your work comp benefits, the monetary benefits that are meant to take care of you and your family after you suffer a serious injury.
So it's like nerves on the company side. People are nervous and terrified on the company side. They're scared, and so they like clam up.
Right.
And then that makes the worker scared and clam up.
Right.
And like literally no one's talking to each other, and everyone stops when communication stops, things are in trouble. Is basically what happens. Last question. You mentioned insurance. It sounds like that adds a layer of complexity to this, where the company might be wanting to go above and beyond, and the person might want to go, like the company and the person might actually have complete alignment, but the insurance company steps in and muddies the waters. Is this the thing where insurance can complicate this and make it a little bit more confusing? It
absolutely can be a situation where you have too many cooks in the kitchen, where you have an insurance company thinking it's doing what it should be doing, and an employer thinking what it should be doing in terms of return to work, in terms of permanent accommodation. The insurance company absolutely is going to want the employer to bend over backwards to find every way possible to get that worker back to work, because it lowers the expense to the insurance company. The employer is looking at it from managing that workforce, and sometimes they don't quite align with the same interests. So sometimes you'll get different answers from an insurance carrier and an employer on things like temporary disability and temporary work restrictions, or even permanent work restrictions and returning to work. Sometimes there's just a little bit of misinformation between the two, or even conflicting goals. One other thing I want to mention on medical care that comes up more now than before is people now are much more informed on mental health than they have been before. We talk about mental health way more than we did 20 years ago. And the work comp system...
We didn't have any data 20 years ago,
And there was a stigma on mental health, right?
True.
There's something wrong with me if I have anxiety or post-traumatic stress disorder. And that's kind of a new part of work comp medical too.
Interesting.
And probably is something that would be a topic for public policy discussions at some point, because it's really hard in a mental health setting to simply trust a mental health care provider picked by my employer, especially if it was mental trauma from seeing a workplace death, mental trauma from a near miss of a major workplace accident. Those things happened, or mental trauma secondary to a major physical injury. You lose your arm at work. You don't just lose your arm. There's a huge psychological component to that kind of major income loss. And so that's another issue in workers' compensation that I will say there are a lot of insurance companies out there that do try to do the right thing and say, injured worker, we are going to defer to you to pick a psychologist or a psychiatrist to talk to on this, or a mental health counselor of some kind, because we understand. There's some that want to pick their own care provider no matter what, but I see a lot more of accommodation in that area, as it should be, and it's probably something that public policy needs to address, because it's really hard to get better mentally if you don't trust the care provider.
Yeah. So I think the bottom line here is that when something smells off and it's not satisfactory, don't get ticked. Don't get angry. Don't take it out on your employer. The same is true with the employee. Don't take it out on the employee. It's two people, or two organizations, two institutions that are nervous and a little frustrated. Instead, take a pause, take a step back, go call a workers' rights attorney, and which you said is a free consultation in most cases. So in most cases, or all cases, I guess. If they call you, it's
call me. I can't think of any claimant side work comp attorney that's going to charge you to talk to you about your case.
All right. So if anybody has questions, then it sounds like it's probably a safe choice just to call you. Of course, we've been joined by Nate Boulton, workers' rights attorney in Iowa. What's the website so people can reach out to you and get some quick answers?
Our website's very simple, workerslawyers.com.
Workerslawyers.com. And we'll put that in the show notes for anybody listening on the go. Nate, thanks so much for coming back in the studio. This is awesome.
Always fun to talk. Thanks, Justin.